Hi. So, by the end of October 31st, LRS 2020 scheme in Telangana was closed. Now, whosoever has applied, and whosoever chose not to apply, did not apply. So, some citizens who are outside Telangana or outside the country, they did not apply. So, what happens to those citizens who did not apply is what I'm going to share with you today. The first thing you must understand is that there is already a case pending in Honorable High Court of Telangana pertaining to the LRS 2020 G.O. Now, if Honorable High Court gives a decision pertaining to that G.O., it applies to everybody. Everybody need not question. So the point now is wait for the decision of the High Court, one. The second is you too can file a writ petition in Honorable High Court questioning the G.O. now. I can't speak for the grounds what you have. There could be many grounds. There could be not having money right now. That will be the common ground because of Corona and other things. You can also question on that ground. Now, whatever are in my mind, the grounds, as an advocate, as a legal officer, I must share the grounds, irrespective of the grounds what you share. So the grounds from a legal perspective are, why developer is not penalized by the government? Because it is a mistake that was made by the developer, because while giving a temporary permission to develop the layout, developer failed to keep up the promise. Why government could be so lenient on the developer? Did he bribe the government to be so lenient towards him? Can't government predict that developer will run away without developing the layout? Or why did the government not collect the entire development fund? Why did government not get insured about this? Is government not having even this kind of common sense and left everything to the developer, trusted developer simply? And when developer did not obey the terms and conditions of the temporary layout sanction copy or order, why government was silent against the developer? So now this is one of the important ground. Why government is not taking action against the developer and why government is penalizing the citizen for the mistake committed by the developer. Government is penalizing the citizen, the plot buyer, for the mistake committed by the developer and the government. Now, if it is an earlier government also, this government must take the responsibility. This government cannot say it is the mistake of the earlier government and we are not responsible for it. No. Government is successive. It's perpetual succession. So earlier, the mistakes of the earlier government will be carried forward to the governments as on date. And so on. Governments change. The governments in power change. But the executive, the operation, the machinery, they stay. They stay with perpetual succession. So therefore, one ground is to take against the developer. And the second ground is why government created this situation. Why government is trying to take advantage of the mistake of the earlier governments. This will be one more ground. This will be another ground. And the third ground could be why government is collecting 14% charges for open space if there is no 10% open space. If 10% open space is available, collect 14%. You can say for developing that 14%, the 10% open space, you are collecting 14%. When there is no 10% open space in the layout, what is the purpose of collecting 14% in addition to the regular amount? Regular penalty is different, 14% penalty is different. This will be one more ground. And the one more ground could be without amending the Registration Act. As on date, prior to issuing LRS GO and after issuing LRS GO, Registration Act says prohibition is permissible only if there are court cases or if there is any direction from the court. Prohibition of registration. Prohibition of registration is permitted only if it is a government property, and prohibition of registration is permitted if government has any accrued interest. And what is accrued interest? If government officer is suffering any ACB case, anti-corruption bureau case, then the properties acquired by him will have a government interest. Government will have accrued interest on those properties. Now, if the corrupt officer is convicted, then government takes those properties. Therefore, government has an accrued interest in those properties. Therefore, registration will be prohibited till that case is pending in the court. Now, Government 22A of the Registration Act says that government can prohibit registrations. Listen carefully. Government can prohibit registrations by a GO. Undoubtedly, as per that provision of law in the Registration Act, government can issue a GO and prohibit the registrations. Accordingly, government issued LRS GO and prohibited the registrations. But that prohibition must be done if there is government interest in the property. Now, LRS GO, the penalty is your registration will be prohibited and building permission will not be given, water connection will not be given. This is the penalty if you don't participate in the LRS 2020 GO. Now, when government can't have any interest, government is not saying that they will take your property. Government is simply saying they will not register the property. Registration is different, selling is different. You can sell without registration also. Registration is only creating or in giving information in the government records. Many transactions happen without registration also. In an everyday life, many transactions happen without registration also. In fact, in real estate also, there are a lot of transactions without registration. Every agreement of sale happens without registration. But law says you have to register agreement of sale also. Now, if registration is prohibited, notary registration will be done. People will resort to notary registration. Anyhow, High Court will address that question. That is a different point altogether. But government, without any provision for private properties, listen carefully. The Registration Act, the law, the amended law of the Assembly, Registration Act is a Parliament Act. State can make amendments. So, state made amendments of 22A, Section 22A. They said they can prohibit the registration with a GO. Now, what registrations will prohibit with a GO? With a GO where government has interest in the property, or government, if it is a government property, registrations will be prohibited. But not participating in the LRS, it will not become a government property. Therefore, my understanding is Registration Act also must be amended, which was not done even today till the date of making this video. That is, post LRS GO, pre LRS GO, or till the LRS application's acceptance was closed, no amendment of the Registration Act was done. It was informed in the Municipalities Act and the Panchayat Raj Act. That is okay. But you have to amend the Registration Act also, because that is the principal act which gives power to the sub-registrar to prohibit registration, or to the entire registration department or its employees, or to the government. So therefore, these are the couple of grounds that I explained right now, based on which you can file a case in High Court, which is a writ petition in Honorable High Court of Telangana, or wait for the Honorable High Court of Telangana to give a decision on the already filed writ petitions. But rest assured, rest assured, government has no power to prohibit registrations for private properties like the properties which are not participated in the LRS. Hope I am clear. Thank you. Thanks for watching. If you have any doubts, kindly comment.